My name's David Payne. I'm with the law firm of David R. Payne, PA. I'm going to talk to you a little bit today about DWIs, some stops, why use our law firm, and what your rights are. So, let's say you've had a wonderful meal with your girlfriend, you've had a glass of wine, you're on your way home, and you run into a checkpoint. What are you supposed to do? Or you're driving home and you don't run into a checkpoint, but a police officer comes up behind you, turns on his lights, and he pulls you over. Let's talk about the first scenario. You're driving home and you come up to a checkpoint. The first thing you should do, as soon as you pull up, you know you're going to be asked questions. So have your license ready and have your registration and your insurance card. Typically, an officer will not have a lot of time to deal with you if you have everything ready to hand to him or her. So if you take a lot of time and you're fumbling around, that gives them more opportunity to stand there and observe you. If you have someone in the passenger seat, tell them before you stop just to keep their mouth shut. That helps a lot. You don't want them talking about what a great party it was that you just left. If you feel like you're intoxicated, the best thing to do is not drive. But if you're driving, you think you're okay, and you're stopped at a checkpoint, make sure you say, "Here's my driver's license, here's my registration, here's my insurance card." At that point, the officer has several rights. He can check you out. The checkpoint is a legal stop, so don't argue with him. Why are you stopping me? They're stopping everybody. They do have the right to stop some people and let others go through. So don't say, "You let the car in front of me go, why are you stopping me?" The least you say, the better it is for you. So when that initial stop occurs, "Hi officer, how are you this afternoon?" or "How are you this evening?" Fine, here's my license, registration, and insurance. If he says, "Have you been drinking?" the best thing to do is tell the truth. Don't lie to the police. If you've been drinking, if you had one glass of wine, you can say, "I had a glass of wine at dinner, but I'm totally fine." Or, if you haven't had anything to drink, obviously say nothing. If he then says, "Well, I think you have been drinking," then say, "What gives you that impression?" Now, typically you'll hear something like this: "I smell the odor of alcohol." If they say something like that, you can say, where are you smelling that from? Is that from my car? Is that from somebody else? Is that, I just had apple juice, I just had orange juice, I just had scope. Whatever might give that impression, ask him to articulate it a little bit more so you'll know exactly what you're dealing with. If he decides that you need to step out of the car, we're going to talk about that in a second. Let's talk about the scenario where you're driving down the road, and this is pretty typical. It's late at night, and more than likely, if you're driving after the hour of 11:30 on any given night, your chances of being stopped for DWI go up probably 30 to 40%. So if you can get home early from your party or your dinner, go home early. The later you drive, the more susceptible you are to being stopped. It's just an inference the police have, and that inference is that people that are out late are up to no good. Or they've been staying out late and they've been drinking all night. So, you pulled over. The first thing you're to do is to be courteous. Do not argue with the police officer. He's only doing his job. His job is to make sure that you and I are safe on the public roadways. Don't argue at all. You do have the right to ask him why you were stopped. "Officer, can you please tell me why you stopped me?" If the officer says, "Just because," that's a wrong answer. He needs to articulate exactly why. If you have an iPhone, I strongly suggest that you push record on the iPhone and record the entire incident. Tell the officer you're going to do that. Have it out. Say, "Officer, I'm going to record this simply because I have the right to record it." Don't get argumentative. If he says you can't record it, then I would certainly want to document that somewhere. But try to get your iPhone out, get the recording going, and then say, "Please tell me why you stopped me." If he says you were speeding, Ask him how fast you were going, where he was sitting, how he knows you were speeding. If you weren't speeding, you can say, "Officer, I was just checking my speedometer. I was doing 55 and a 55. I wasn't speeding. I was going with the flow of traffic." If he says you have a bad tail light, ask him if you can exit the vehicle and inspect that with him. If he says you have a bad headlight, the same scenario. If he says you were weaving, you need to make sure you know exactly where in the roadway he says you were weaving. For example, "Well, I saw you weaving." Well, can you give me a landmark as to where you saw me weaving? And what steps did you think I was taking that were wrong? Or, for example, an animal could have ran out in the road, you could have been avoiding another driver, whatever, you need to be able to articulate that. The number one rule is to be courteous, realize that they're only doing their job. At the same time, you should have your license, registration, and insurance card readily available to hand to him or her when they stop you. Now, from the time they stop you, you have 30 minutes to ask for a witness. If you're alone, you can ask the officer, are you stopping me for probable DWI or whatever? Because he'll say it by then. He'll say, "Listen, I think you may have had too much to drink. You were weaving, I've stopped you, I think you may have had too much to drink." At that point, you have a right to call a witness. And I would ask the officer to let you go forward and do that. So I would say, "Officer, I don't mean any disrespect, but I understand that my rights are that I have about 30 minutes within which to get a witness here who can observe me taking any type of test that you might be giving me." And I'm going to go ahead and call that witness now, if you don't mind. If they say you can't call a witness, then there's a real problem. They have a real problem at that point. Make sure you call somebody who's going to be there on time and someone who makes a good witness. Don't call someone who's been convicted of 5 DWIs. Call someone who you know is articulate and who has a good standing in the community. Now, let's say your witness arrives and the officer says, "At this point, I'm going to give you a field test." You have the right to reject a field test. Now, most people don't know that. It's difficult to say your ABCs backwards if you've had 5 cups of coffee in the morning and you're starting your day. It's extremely difficult to say your ABCs backwards if it's 12:30 at night and you've been working all day and you're driving home. So you need to tell the officer, I mean no disrespect, but I may have a dyslexic condition, I may have an attention deficit disorder condition, or I may have a condition I just can't walk very well. We've had clients in the past who had to use canes or crutches in order to get around, and they were made to do field sobriety tests without the aid of their crutch, which is ridiculous. In that situation, if you have a physical impairment, you need to tell the officer, I have real issues with standing too long. I can't hop on one leg. I cannot do a field sobriety test. At that point, the officer has to give you a breathalyzer test. Typically what they'll do is they'll give you the field test first, use that as a platform, then to give you a breathalyzer. But if you say no to the field test, then they're going to go straight to the breathalyzer. Now, here's the problem, and most people fail to understand this. If you refuse to do a breathalyzer test in North Carolina, you will automatically lose your license. It's just that simple. And there's really not much we can do to help you at that point. Our suggestion is fully cooperate with the officer. If you feel like you haven't had too much to drink, fully cooperate, move forward, and give a breathalyzer test. Now, what typically happens is people will attempt to give one, and it won't register. And then they'll attempt again, and it won't register. We've had clients attempt 14 times. One gentleman attempted 14 times to blow on the breathalyzer, and eventually the officer got frustrated and said, "We're going to jail." Okay? Don't think you can beat a breathalyzer by barely blowing. Blow. Give it your best effort. And if there's a reading, they have to get 2 readings. If there's a reading, make sure you ask the officer what the reading is. And again, if you have your iPhone, your tape recording should be going on the whole time. Officer, what did that read? And if he says, I'm not going to tell you, say, will you please share with me that evidence? Because if it is below .08, unless you have a commercial driver's license in North Carolina, then technically you're not legally intoxicated. So I would ask for him to articulate that. If you try and try and try and you cannot post, what they'll typically do is arrest you at that point, and then they'll cite you for refusing to give them a breathalyzer. It's extremely aggravating. I know that doesn't make sense. You've tried and it doesn't register. At that point, I would argue, officer, I've tried to blow. I can't blow. I want to voluntarily give you a blood sample. So if you would, please take me to the hospital and let them draw blood so that we can get a sample, because that is a great way to determine the exact amount. A lot of people believe that if there's no breathalyzer, somehow they can bypass the issues related to DWIs. That's not true. DWIs in North Carolina are premised on two primary issues. Number one, if you're legally intoxicated, .08 or greater, they make the argument that you are then violating the law. However, the officer can also testify that you have demonstrated the effect of alcohol or the effect of some type of drug. In other words, if they can articulate that they believe that you were intoxicated, then they may have a case. Typically, though, the district attorney's office likes to see a breathalyzer test or a blood test, as it's the best evidence to show the level of intoxication. Let's say you've gone through, you've taken your breathalyzer, you've failed. What's going to happen next? The next thing that's going to happen is you're going to be taken downtown and you're going to be booked. Don't freak out. It's not as bad as it seems. You're going to be booked, you're going to be held in a tank, and you'll typically make your way in front of a magistrate who will set a bond for you. What we would recommend is that you have a phone number handy of someone that you know is a good friend that could come help you post bond. Most of the time it's going to be a very small bond, unless you've done something grossly aggravating, like you were rude to the officer, like you fought back against the officer. Anything like that's going to raise your bond. So that takes us back to the first point. Be courteous the whole time. Once you get arrested, you're going to get a court date. The court date is a mandatory show-up date. If you fail to show up, you're going to be rearrested, and this time it's not going to be as nice as it was the last time. In other words, you're not going to get out as easy. As soon as you get your breathalyzer results, as soon as you're charged, you need to contact our law firm. Now, a lot of people say in North Carolina there's no reason to hire a lawyer because all the law is set and there's nothing you can do. We disagree. DWI cases are extremely complex. There are multiple levels of sentencing, there are multiple levels of punishment, and there is room within the act to work. The primary issue that you need to address is how important is your time, how important are your rights, and in so many situations, is it worth taking the time to hire a law firm that knows what they're doing? One thing you need to understand, the district attorney's office, the arresting officers, and everyone involved in a DWI prosecution have been highly trained. In other words, these are seasoned professionals, and they've been trained to do one thing, and that is prosecute you. We've been trained to defend you, and that would be our honor. What we want you to do is consider contacting us immediately. The first thing we're going to do is determine whether or not there's enough requisite evidence in order to convict you of a DWI. That will entail our firm going down on your behalf, looking at your file, and looking through to try to find every piece of evidence that they may have against you. In particular, we'll be looking for your blood alcohol content reports and other materials such as statements from witnesses or otherwise which may support their claim. If we find a conspicuous absence of those materials, That will help us articulate a defense on your behalf. Another reason why you want to hire us is because we're going to save you a tremendous amount of time. The time we're going to save you entails time away from your work, and it also entails, if you're convicted, us attempting to get you a limited driving privilege as quickly as we possibly can. If you did not refuse to take a breathalyzer test, you should maintain your license status during the pendency of your hearing on your DWI. What we need to let you know is you'll begin in the area of the district court. In district court, you will not have a right to a jury trial. Typically, in the district court, we have tried cases before in front of a district court judge on the issue of whether or not they actually had a right to charge you. Most of those cases entail a situation where there is no blood alcohol content evidence. And if that's the case, we can't make you any promises, but it certainly helps your defense. If we find ourselves in a situation where a district court judge has heard the evidence and has opined that you are in fact guilty, then we have the ability to take it to the superior court level where you do have a right to a jury trial. Now this could take up to 12 months. The whole gamut of start to finish could take around 12 months. During that period of time, we want to try to keep you driving, provided that you comply with all the requisite driving laws and providing that you did not refuse the breathalyzer. So our firm will be able to keep you driving and will also be able to protect your rights and save you valuable time. This is just a brief sample of some of the issues related to DWI law. It is extremely complex in the state of North Carolina. Punishments for DWI offenses range from 5 being the least to 1 being the most severe. 1 would entail aggravating factors such as having a child in the car or blowing a high level of alcohol content. All of those things we take into consideration. All of those things we utilize with respect to our knowledge in handling your defense. We want to work for you. We want to do a good job. We encourage you to contact our law firm at www.drplawfirm.com or 828-258-0076. Thanks.